Good evening. Happy Monday at 6 p.m. My name is Debbie Marker. I am right now I'm a permanency grant administrator for DCYF, which is a really a title that's all about working to engage families and our community partners in making case decisions. So I'm actually really excited to be able to present to you all again about permanency options. I've been with the state of Washington as an employee for a really long time, like over 30 years. I know that's a shock to you when you look at me, but I like to say I started really young. Ryan's laughing. And I've done, I started in the field. I worked in adoptions in CFWS. I was a supervisor in the field for 19 years. And then I went up to headquarters and totally got lost in the bureaucracy of DCYF headquarters for a while. And now I feel like I've kind of found my way into, I loved being the adoption program manager for several years. And now I'm leading this grant that we have, a collaborative grant with our federal government. So I'm here to talk with you tonight about permanency options, and feel free. So I like to have discussions. And I don't know, Ryan, if people can unmute and talk if they ask questions. I like that. Ryan's giving me the thumbs up. If you'd also like to use chat, when I'm talking and sharing my screen, I have a more difficult time seeing the chat, but I've figured out how to put it up. I'm here tonight. I actually brought in one of our grant facilitators because she is an awesome engager and community collaborator. Her name's Paula McJohnson, and Paula, I was going to let you introduce yourself briefly, and then we'll get started.
Hi, everyone. Thanks, Debbie. Yeah, I'm Paula McJohnson. I've worked in child welfare for about 14 and a half years between Washington State and the state of Michigan. I was a CPS. I worked in CFWS, FAR, and then I was the regional BRS program manager. And I came onto this position because I'm super passionate about permanency for youth, and being the BRS program manager, I was seeing that we had our children and youth were lingering in foster care for long periods of time. So I'm really thankful that I'm in this position, and I'm happy to be here tonight.
Great, thanks. So we're going to start talking kind of about permanency options, what they are and how we get there. And it's really, I like to start from the standpoint of how we make decisions within our organization. So Division of Children, Youth, and Families is really supposed to be making decisions in a shared planning meeting format. And we know just from our work with the grant that that's really not always the case. We've kind of moved away from that. So I want to kind of start with talking about why we use shared planning meetings, kind of what they're about, and why it's important that everyone comes to the table. And I'm actually talking figuratively now, because with virtual meetings, there's not really a table, but I still think of it as that way. We all need to have kind of the same information and the same background. So my first question is, has anybody that's on tonight ever attended a shared planning meeting? And they can also go by permanency planning meetings, family team decision-making meetings. Those are all under kind of the shared planning meeting umbrella. See, I really like to have a discussion, so I really try to ask questions. I'm just wondering then if you've ever been to a shared planning meeting, or if you've never even heard of it, if you've been to one, kind of, did you know when you attended it, really what it was going to be about? Or did you feel like it was a meeting where you were kind of listening to the department tell everybody kind of this is how the case planning is going to be? Because really what we're trying to move away from is for these to be compliance-based meetings. And really what the emphasis is, which is that there are team meetings where there's communication around what is going on with the case and how we think we can move forward as a team, as a part of this case and this case team, to kind of either safely reunify or a move to one of the other permanency options. We really want to stress that these meetings should be transparent. We all should have the same information. And in doing that, that's why we like to talk about kind of what permanency options are all about. Because what we found is that even workers in the field are confused about what these mean. And a lot of times don't bring them up until later on in a case instead of at the very beginning of a case. So the first and foremost permanency option is reunification. And I'm going to talk a little bit about reunification because typically when we look at reunification, what we hear in meetings are, what has the family done? Are they attending visits? That's maybe one point, but it also may be what services have they completed? Service compliance does not necessarily mean that it's safe for a child or youth to return home. And so really the question that we want to bring back to the team when we're looking at reunification are the safety concerns that initially brought the child or youth into care, are these manageable? Is there a way to place the child or youth back into the home that's safe and still allow parents to maybe do services or whatever other treatment needs that they may have while also parenting their child or youth? We're asking the team to look at what are the conditions to return home. And you're going to hear me say kind of over and over again that it's not just the department and it's not necessarily what the judge has ordered. A lot of times we're finding that when we go into meetings, there's an initial fact finding where a judge has ordered maybe a whole list of services that the department's just presented to them. This is kind of our standard checklist of services. And what we really want to do when we bring a team together is to say, what really does this family need to do to safely parent? And what does the home need to look like? So instead of saying that they need to complete drug treatment and they need to have 10 clean UAs and they need to have their parenting assessment and follow all recommendations, we're saying if they have a plan in place, if we were to place the children home, like what's their backup plan if they feel like they're going to start to use? Is there's a safe person, grandma or best friend that the kids can go to? And who would they call if they felt like they were going to relapse, if drug use was the issue? What does the home need to look like? If there's, if neglect was the issue. Paula, did you want to jump in? I don't know, I saw you.
Yeah, I didn't mean to unmute myself, but one thing I just wanted to say there is that something that I like to say to folks is like, what is the behavior change? What does that need to look like? Because it's really, if we can get a social worker to articulate what it looks like in terms of a behavior change for a parent, we're really onto something outside of what Debbie was saying, the compliance, because that seems to be where we're stuck right now.
When we're looking at reunification, one of the things that we'll hear a lot is kind of our own biases come through. And it's really important to recognize that a standard that I may have, right, and how I would want my kids to be raised is not necessarily what this family needs or what it needs to safely parent. So you want to be able to recognize your own bias from manageable safety actions. And it's really difficult to do because I say this a lot when I talk about permanency options, is that nobody has a crystal ball. So in saying that, we also have to look at history and whether historically there may be times where the families attempted to safely parent and then not been successful, and like look at those reasons why, and maybe if something different needs to be done. So we would assess our judgment and our recommendations on possibly history. But one of the things I hear about over and over again is attitude, the parent's attitude. And so I'm just going to throw this out there right now. And that is that a parent doesn't have to like us to be able to safely parent. And so as a supervisor, I would hear all the time, oh, this parent hates you. They think you're a terrible person, Debbie. And I'm like, I don't care. Like that has nothing to do with whether or not they can safely parent, right, their kids. And so It's separating like our own internal kind of what we think should happen, our should list, from what we're really seeing. Like Paula said, what the behaviors would look like, kind of what might be going on. Someone that hates me can be a good parent. I wrote that down to remind myself because I used to hear that a lot in the field. The other piece is also kind of responsibility. Are parents taking some ownership for what they need to do? And that's a great indicator, right? If they are. It doesn't mean that they have to agree with everything that the team or that the worker is saying. Other factors that we want to consider. Oh, look, I even wrote crystal ball in the PowerPoint and I did not know that. It's something I like to use. Is the age or youth of a child, right? The age of the child or youth. So age is a great factor because we know that younger children, there's more things that we have to be concerned about in terms of protective factors versus older youth who may be able to have some self-protection skills and are able to go and talk with someone and kind of have more of ability to keep themselves safe. And specifically, we want to look at, is there a plan that could be put into place that would allow a child or youth to return home? Reunification is always, right, our main goal up through any other plan that we look at completing with the child or youth. And so it's always a plan that if another, for thinking that we're going for termination of parental rights, we'll talk about that in a minute. Reunification would always be a backup plan because if we've seen families turn it around when we thought we were going on one path to be able to go back and look at reunification if we didn't think it was possible. Any thoughts or questions about reunification? I think we all think, oh yeah, we know what that means, but what we're finding when we're looking at our team meetings and we're talking about reunification is that it's really compliance based. And so I really hope you hear me saying that it's really not compliance based, that we're really hoping that it's behavior based and safety based and looking at, is there a way to safely, to manage those safety threats so that we can reunify? So the second permanency option is adoption, and adoption as a permanent plan. The biggest question that I get is the difference between adoption and guardianship. Adoption is the most legal permanent option after reunification because it essentially creates a new legal family for the child or youth that cannot be easily disrupted. It's not, no one can go in and file something and try to disrupt an adoption. It is really a permanent plan. And so it's really considered as a plan that we would look at for younger youth in particular, because one of the notions behind adoption is not only is reunification not likely in the foreseeable future, and my question is always, what is the foreseeable future? But bigger than that is there any way to continue that parent, child, or youth relationship that would be beneficial to the child? Because if there is, then we don't really want to look at severing it, right? So for adoption, what we're really saying is if we continue that relationship with the parent, it would be damaging to the child's integration and stability into a permanent home. You have to really think about that. And again, we don't have a crystal ball. So thinking into the future is really difficult. And again, we look at history of the parent. What we tend to say is, oh, this parent had several terminations of parental rights. They've lost other kids. That's not necessarily for sure for this new child. You know, another piece is, are they making visits? Are they attempting to have a relationship? Is there a way to maintain that relationship between the parent and the child or youth so that it could be continued in some way that's safe for the child and doesn't affect the stability of the child? And if there is, then adoption's not the option that you want to look at. It would be it's a guardianship, and we'll talk about that more in a minute. Adoption for dependent youth always provides a subsidy. And while money is not the reason that we make a decision, it is something that's taken into consideration. I mean, just going to be transparent with this because it is definitely helpful for especially relatives who choose to adopt to be able to have a subsidy and medical care provided for the youth that they're going to adopt. Any questions about that? Other things that we look at are we able to?
Yes. I'm already confused.
Okay.
Did you say? Did you say guardianship is better if there's a relationship with the parent than
Yes.
adoption?
Yes.
And did you say with guardianship, you do get subsidies and medical help?
No, adoption. If I said guardianship, I misspoke. You do
Okay, so with
guardianship.
adoption,
You do with guardianship, but in a limited capacity, and I'll talk about that in a minute.
okay, thank you.
Yes. So the real difference between adoption and guardianship, Alice, is that when you're looking at the parent-child relationship for adoption and you're looking into the future, you're saying there's really no way to sustain that in a healthy manner for the child or youth. Now, a lot of times parents are missing, they haven't been around, there is no relationship. Or there is a relationship that's been so abusive that it's detrimental to the child to have it continue in any way, shape, or form, other than maybe through some real peripheral, like an open adoption agreement. But if you have a relationship that you feel like could be salvageable with boundaries and structure around it, then we want to look at a guardianship. The guardianship law, in a guardianship, a Title 13 guardianship, there's only one difference between a guardianship and termination of parental rights. And it is the 6th point of law, which is continuation of the parent-child relationship is detrimental to the child. So a guardianship, in terms of what we have to prove in court, is exactly the same, except we're saying there is a way to maintain that relationship through some sort of visitation plan without terminating parental rights. Because continuing that relationship in some way can be healthy and not detrimental to the child or the youth's stability. The reason why, as an agency, DCYF prefers adoption over guardianship for younger children, is because you have to predict for a longer length of time what that parent-child relationship is going to look like, right? So if you have a 2-year-old that's with a grandma, and dad is a parent that's involved, but dad is continuing to use drugs, and he shows up at grandma's house, and he's continually disrupting the placement, and he's saying he's going to steal the child, that would probably need to be an adoption case to allow grandma to have kind of that authority and that say over the boundaries for that father. But let's say in that same situation that grandma has the 2-year-old and dad is saying, I know I can't raise my daughter, but I want to have a relationship. Grandma's saying, I can control it. I'm going to let him visit when he's sober, and he's not going to be around when he's not. And I want to be grandma. And I'm committed to this child for the rest of her life, but she's always going to have this as her dad, and she's always going to know this is her mom. Then even though she's 2, we'd be looking at a guardianship, because there's a relationship there that we can preserve with the parents in a way that's stable and provides enough boundaries for the guardian that they're comfortable with, and allows that child to still maintain a relationship with her birth parents. A guardianship by law requires a plan of visitation, because we're saying that continuing that parent-child relationship would not disrupt the stability of the child or youth and is beneficial to the child or youth. I look at this, we And I wonder, why aren't we doing more guardianships? And a lot of times it's because the people that sit at the table in the shared planning meeting do not understand the difference between what adoption is and what guardianship is. And the agency has some propensity to want to terminate parental rights. I mean, that's just tends to be the way that it goes. And what we're here saying is that a guardianship in a lot of ways can be a stable and okay solution if it's in the child's best interest. And that's another open question, right, that the team decides on. But if there's a way to keep the child safe and they cannot return home, so that's always the big F, right? Reunification is not possible. There's been a long enough time to where we can say the parents have had their chance, they're not visiting or they're not making changes in their life to where they can safely parent. What are we looking at? We want to be able then to move to the next best plan for the family, and it could be a guardianship. It may also be adoption, but if there's a way to say that that relationship's positive with the parents, we want to look at guardianship. Now, Alice asked about subsidy, and there is also for a Title 13 guardianship a subsidy available that's very similar to adoption support, but the major difference is it's only available to relatives, and there's some specifics involved that must occur for the relatives to qualify for the subsidy. I'm not going to get into those specifics. I mean, I know them, but they're confusing. But and the facilitators who facilitate shared planning meetings also know them. But they make it somewhat difficult for relatives to get subsidy, but they can, but impossible if it's a non-relative to get this subsidy that matches adoption support. Anyone who does a guardianship in our state can qualify for non-needy relative assistance. It's just not as encompassing as the adoption support is or as the relative guardianship assistance program is. So I'm going to take a breath and see if there's any questions around that.
I have a question,
Alice,
Debbie.
go ahead, Ryan.
With the new guardianship law, is there still such a thing as a Title 13 guardianship?
Great question, Ryan. And yes, there is. So there's no such thing anymore as parental custody agreements.
Right.
So the new guardianship law eliminated those, but it did not eliminate Title 13 guardianships. And the subsidy is only tied to a Title 13 guardianship. You cannot get the relative guardianship assistance program subsidy through they're called Chapter 11. They're the new they're actually on the next slide.
Okay, sorry.
So it's called a limited guardianship. That's okay. You're a great segue for me. So thank you. You and Alice both were great.
Debbie, this is Barbara. As a CASA, I am currently in a case where we are moving to guardianship with a family member. And I don't know if you have time within the scope of this, but if you do, can you comment on some of the key things that we should be looking for in the visitation plan?
So great question, because I'm going to tell you what I think about the visitation plan is. I think they should be developed. If you're saying that this guardian is appropriate to raise this child, then I think the visitation plan should be developed between the guardian and the parent, and that we don't develop it at all. I mean, we can approve it, but really it's their plan, their ownership. And if we're saying that they're going to make good decisions around the child or youth, then they would be the ones developing it. So once that guardianship's in effect, we really have no control over it anyway. So I think we get caught up in feeling like we need to create a plan that's going to keep this child safe. And the plan is that the guardian is going to keep the child safe. And if we really feel like that caregiver is capable of doing that, then why wouldn't, then they would be the one to create that plan.
I would agree with that. What I would say though is, and maybe in this particular case, maybe in more cases as well, but I think these folks feel a little intimidated by this whole process. And so I would like to be able to support them in that, you know, by maybe offering some suggestions, giving them some outline, giving them some direction where to go. And I've never done this before either. So that's why I was sort of asking maybe for some guideline.
Sure. So I would be, you know, I don't know what visits are now, if they're supervised. It's really important that the caregiver understand that there's not going to be anybody to supervise those visits anymore except them. So I used to get calls from caregivers who said, wait a minute, I didn't know I was going to be supervising these visits. Like, what happened? I went from office supervised visits by DCYF to now I'm supposed to be doing these visits. And so what you're talking about, Barbara, is really important, is that there's really a clear understanding of what those expectations are going to be and what they look like. So my first question to the guardian would be, what are you comfortable with? What are you comfortable doing? What are you comfortable with? And what do you think is best for the child or youth? I mean, I try to distinguish between the two.
Debbie, I was just going to add on there too. The way it might help to think of these, Barbara, is that you're actually developing a parenting plan between the new caregiver and their parents. And so where you might actually find better resources than us here in this field is actually going to the court facilitator and say, could I see some documentation for a parenting plan to give you an idea of kind of what restrictions you can put in place on the other co-parent? In a lot of ways, divorce is a better example.
Right.
A divorce situation is a great example for looking at what the future between the old parents and the new parents are going to look like. And the courts are already familiar with that language and restrictions and all kinds of good stuff.
Great point, Ryan.
Awesome. Thank you.
So Linda wrote in the chat, the Title 13 guardianship offers no subsidy for the guardian. So if the guardian's not a relative of a specific degree, you're absolutely right. If the guardian is a relative, and it's by definition in RCW, then they are able to qualify for a subsidy, but they have to jump through some hoops. It's not an easy process. I'm going to be really upfront about this. And it's primarily because in our state, we have a subsidy program for guardianships that's completely federally funded, which means it has to meet the federal requirements for the rules that they determine to fund it, or it's not available. So that means they have to be a relative that's defined in our state, which is somewhat open, but not open to like fictive kin, which in a lot of states, their relative definition includes fictive kin. And so they're able to qualify a lot of people that aren't blood related as guardians. And so a lot more guardians qualify for the subsidy, but not in our state. It's very, very, very limited. And then they have to be licensed. And that's not an easy process to go through, to be foster licensed. One of the things I was going to ask you, Barbara, you said that you're looking at guardianship. Was this talked about in the very beginning of the case? And did everyone know kind of, even though you might have been looking at return home, like what to do if you wanted to follow through with a guardian, which would be that the relative needs to get licensed to qualify for the subsidy, to qualify for the guardianship subsidy is what I meant to say, not as a guardian. You don't have to be licensed to be a guardian. You do have to be licensed and a relative to qualify for the subsidy.
Yes, and in this particular case, the family member did not want to go through all of the steps to become qualified and determined that they would be financially okay without the additional funding. So they chose not to do that.
Okay. And yeah, that it's just always been frustrating to me that we're so limiting with this and that it's not open to all guardians. And I brought that up because Paula actually has an example of a case. Paula, did you want to talk about that just in general, where it's a length of stay case that she's been working on? Do you know what case I'm talking about, Paula?
I mean, I have two.
Okay,
Are you talking about the mom in jail, prison?
I'm talking about the one that guardianship was never mentioned and they were going to terminate parental
Yeah.
rights.
So I got assigned the case after it's been open for almost 3+ years. And at my first meeting, we started talking. I like to bring the permanency planning matrix to the meeting and talk about all the permanency options out there. And we started talking about it. And the relatives who've had this child, guardianship had never been discussed with them. They had no idea what it was. And so they really started wanting to ask more questions about that. The department was already moving to termination. And it turns out it's definitely in the child's best interest. Mom calls them every night from jail. She writes them letters. They have they very consistent communication and letter writing. And so unfortunately, talking about guardianship 3 years into a case when a termination petition has been filed is going to delay this case even more, because this is what the relatives really want now. They really want to wrap around the mom and continue that relationship, because it really is in his best interest, and this is what the mom wants as well. So if they hadn't talked about that prior in any other meetings, and the relatives are not licensed, so they have to go through the licensing process, and then the child has to be in the home 6 months after, after they're licensed, the child, that they have to be licensed for 6 months. So we're a long ways down the road in delayed permanency for that little guy, but definitely it's in his best interest. And his mother is going to be out of prison in a year or so. But termination was not, it's just unfortunate that termination was kind of what they set as a goal, and they went with that without discussing all the other permanency options.
The reason I love to talk about permanency options with everyone is just because we want everyone to be knowledgeable that works in dependency cases about what these really mean. Like I said, I think earlier, workers aren't necessarily understanding the difference between adoption and guardianship and which way would you go. And what it does is it delays permanency. Our state is at the bottom of the list in the nation for timely permanency. I mean, this is why we received the grant that we'll talk about in a minute. We're not doing well. And our system is a foster care system. It's not set up to raise children and youth. I mean, I think there's another news story going to come out that's going to tell you about how crappy we are at this, right? With the hotel stays and everything else. We are not an agency that is set up to have children and youth in care for years and years. And so part of this is that when we talk about planning for a family, is that everyone comes to the table and you all have this, at least some basic understanding of what these are and what they mean. And I see that, I think, was it Bonnie that put some information about a parenting plan? And then, yeah, and then Linda on Title 11, Linda, I completely agree with you. So Title 11 is actually, I think, created about inheritance, right? The department, I'm not going to talk a lot about it because DCYF has not really made a stand on this in terms of, is it really a permanency option? Because they can be easily overturned. And they're set up, anybody can ask to be a guardian of a child or youth, primarily to handle their money and inheritance. And but the law is so broad that they can be used in other ways. And so I expect that may happen. These are just like the points from the law that as it stands right now. And that there is no more. I think the biggest thing is, if you've ever heard of non-parental custody agreements, they were called RCW 2610. They are no longer in effect. So the guardianship I'm talking about is called a Title 13 guardianship. That is actually a specific chapter written for dependency, what used to be called dependency guardianship, for this dependent youth. And looking at kind of concretely the difference between adoption and a Title 13 guardianship. And like I said earlier, adoption provides lifelong legal ties. It's a legal change that's permanent for a child or youth. And if that's something that's important for that child or youth, then that's what you would need to lean towards. Whereas a Title 13 guardianship legally ends when the child or youth turns 18. For adoption, Medicaid can be offered up to age 21 through adoption support. And for Title 13 guardianship, whether it's through a relative guardianship assistance program subsidy or that CSO grant that I was talking about, the non-needy relative grant, it is only offered up to age 18, unless that changed this year, because I'm no longer the guardianship guru that I once was. And so, but I'm pretty sure, I think it's still age 18. An adoption cannot be modified as a legal arrangement. It can't be terminated or modified upon a motion in court, but a guardianship can. So the reason guardianship is not equal legally to adoption is because a parent can notify the court and ask for a hearing to say, I want the guardianship modified or terminated because I've made substantial change in my circumstances. Now, there's not been a lot of incidences that I'm aware of on dependency cases where parents have been successful, but there have been instances where parents have continually done it, continually gone to the court, and the courts allowed them to file motions to where the guardian said, I give up, take the kids back. And they've disrupted the guardianship based on that. And that's really a whole part of looking at the stability for the child or youth and saying, is this a parent that's going to try to disrupt this child in placement or this youth in placement? That's a consideration that we look at. I always like to include this last piece because I just think it's weird. You can adopt in our state if you're 18 or older, but you cannot be a guardian unless you're 21 or older. Just, I don't know why. Ryan probably knows the answer. It's probably trivia that Ryan knows, but I have never figured it out. I just think he's saying no, he doesn't know either. Yes, Tamara.
Thank you. I had a case where mom was really into drugs and gangs and things like that. She tried to kidnap the kids when we would have visits at CPS, and just a mess. And her sister and her husband ended up adopting this child. Well, mom got her act together. The people who adopted the child, they all fell apart. And when I followed it up on later, I found that the child ended up going to the birth parent under a guardianship. And it worked out great. She got it all together, but it's just like, my goodness,
Right.
You know, the mom can't get her own child back. It has to be done as a guardianship.
Right. Right. Well, because her rights are terminated. So, I mean, that's, yeah, that actually, I like that the family, or I don't know if they came back into the state, worked that out, but that they still they were willing to look at mom again, right? Because I think that's important, because people really are able to make change. I mean, that's every time I hear a worker say this parent's never going to get their kids back. They've had 5 prior terminations. And I'm like, are you in the right job? Because really we're an agency that believes people can change. And we really want to go in with our open mind. And yes, I get it's frustrating, but we really need to look through that to say, what maybe can we do differently? And that's kind of what we're about with what we're doing with the permanency grant around this. So Paula mentioned the permanency planning matrix. It's a cheat sheet to permanency options. If you've ever been in a shared planning meeting, and so I'm going to ask Barbara, I'm going to put you on the spot because it sounds like you've been to one of these meetings. You've talked about permanency. Were you provided the permanency planning matrix so that you could look at?
I have been to a shared planning meeting. I have been given that matrix at a CASA training, but I don't remember being given it. Yeah, I don't remember at the shared planning meeting being given that.
So, I mean, the example I like to give is, okay, I'm going to use myself. I hate to go deal with any kind of auto repair because I can look under the hood of a car and I am lucky if I can figure out the dipstick, like, and what really that is. I know nothing about it, and I'm completely intimidated by mechanics because they come out and they say these words, and I just nod my head and say, okay. And this is why I kind of asked at the beginning, who's ever been to one of these meetings and did you really get what was going on? We bring CASAs in, we bring parents in, we bring family supports in, and we use jargon and things that we're familiar with and act like you all should know. And most people are too intimidated to say, I don't have a clue what you're talking about. One thing we can do to help that is to provide everyone before the meeting with this matrix that explains in somewhat simple terms what it means, what the objectives are, what the legal status is, what medical is provided, what it means for legal custody, kind of what each of these give a family or a child or a youth. And that's really important, is that to be able to, so Ryan, you're gonna have to tell me how to do that. He wants me to drop it into the chat and I don't know how.
So take that file and just literally just drop it in chat from your
Okay.
desktop.
Okay, I will. I'll do that. I'll do that when I get this off. I can't do it from this, right? I have to go to the file and move it.
Or
Okay,
you can,
got it.
or you can, are you in chat?
I
See
have
that thing
chat
that looks,
up. Yeah.
see that thing that looks like a piece of paper?
Yeah.
Click that. And then you can go to the file on your computer.
Okay, perfect. I'm going to try that right now and try to talk at the same time. But anyway, this goes over all of the options that we've talked about and kind of talks about the same things. So, and here's your limited guardianship piece. All right, it tells who has legal custody. It talks about if it can be, if you're able to go in and make changes to it, or it can be overturned. It gives you that information. And so, so I can't do that and talk, Ryan. I'll have to do it in a minute. I'll put it in the chat in a minute. I can't multitask. It's too late. So permanency planning matrix, if you've never seen it. So I think Ryan had me talk about this at a presentation. I think we were in Spokane, Ryan, and I had a bunch of people, and I remember this because Ryan had to come and take the microphone away from me. I don't know, you probably don't remember that, Ryan, but I was talking so loud in the microphone, and I was having so much fun with it too, because don't give me a microphone, I go nuts. But he had to quiet it down. Paula's laughing because she's probably heard this story, but I asked the group, who had all ever seen this permanency planning matrix? And I think 10 out of 50 some had ever seen it. And I bring it up all the time because it's so important to me that this is what equals that playing field. This is what equals our team, is that brings you that information, right? That you can come in and make informed decisions. How can we ask parents to give informed input about what they'd like to see happen if they don't even know what we're talking about? I know, right? It wasn't awkward. You didn't have a problem with it. It was really funny. But I did see in one of the evaluations, someone said, I felt so sorry for the presenter when Ryan took her microphone away. The other piece of this is, and this is going to be leading to concurrent planning. And so Paula, you tell me if you want to start on the next slide or not with concurrent planning. I'll do this segue in. But really that permanency planning starts from day one. And somehow we've really moved away from that thought. And we're more into if this, then this. So if this doesn't work for 12 months, then we're going to try something else. And so I'm going to go back to my point that I made earlier, which is this is not a system to raise children. This is a foster care system, and it's not a pretty system to be raised in or to be raising children or youth. And so thanks, Paula, for answering that. And so if we're not talking about what we need to be looking at, all of our options from the very beginning, and sometimes that's hard, it's still important. Then we're doing that family, that child, that youth a disservice because, for example, in the case that Paula talked about, we wasted a year of that child being in a temporary situation because nobody talked about guardianship, because nobody knew. We still hear from DCYF management that only children of a certain age can be in a guardianship. And we're like, no, that's not true. That's not what it says in the law. what it is, what you look at is there a way to make that parent-child relationship, to continue that parent-child relationship and ensure that it's still safe for the child or youth? That's what we look at for a guardianship. So we want to be talking about not only reunification, but the other plans that we want to consider for that child or youth throughout the life of a case until permanency is achieved. We want to be looking at primary attachments. We want to make sure we're preserving cultural and family connections, that we're keeping kids. I mean, we've had workers, we've had CASAs, we've had caregivers say, we don't want you talking to the youth about what's going on because they don't know and it will disrupt them. They know, their imagination is worse than reality. Okay, we are to be transparent. We need to have age-appropriate conversations with youth in the case, with parents in the case, so that they're able to make informed decisions and to also feel that they still have some control over their lives, right? Even for a child or youth to say to Paula, when you go on the meeting, would you just say, I want to go home? I want a picture of my parents. I mean, how often are we asking children or youth, do you have a picture of mom and dad to have by your bedside? I mean, it's not often that we do that. And yet, because we think, oh, if they think of them, it's going to make them be sad. They're sad. If they're not sad, they're hiding it, and that's not healthy. So I had a AG who told me they took a 3-year-old that had been in a placement from birth to age 3, and they made a decision to move her to New York to a relative placement with no transition, with no talking, no, actually, I think she was 4, no talking. And the AG said, but it was okay because the youth never cried. They didn't do anything. And I said, are you kidding? And they never saw their family that they'd lived with for 4 years again. And I said, are you kidding me? That's got to be so traumatic. Like, my dog has fits when I leave for the day now, since I've been working from home. I mean, kids feel these things. And if we don't help them process it, we're damaging them further. So
I just want to add something on there. It's like, it's really important for kids, you know, if age appropriate, and teens to be part of the conversation, because it's really their life. And one of the cases, I met a young girl, she's 15. She was very, very angry at the department, very angry at her dad for what had happened. And she was in foster care, and she was very angry at the foster parent. And we had a good conversation about coming to the meeting, and she was able to give us ideas. So she can't go home to dad, she can't go home to mom, and she was not gonna stay in foster care. Her plan was to run away. And so she was able to bring her best friend and her best friend's mom to the table. And we were able to go and, you know, do the background checks, all of those things. And that case is moving into guardianship with her, and she's doing phenomenal. She just got a job. She's in driver's education. She went back to school, all these things that she wasn't going to do because she was in foster care. And she felt like she was being punished by being in foster care, by telling what was happening to her with her father, and that no one was inviting her to all of these meetings. They were happening without her, and they were about her. So I think it's just such a huge, it's so huge for youth, and if they're, you know, age appropriate children, to be at the meetings to say what they would like to see happen or ask questions. Is this my slide, Debbie?
this is your slide, Paula.
Okay. I just want to see if Ryan dropped something in the chat. Difficult. Yes,
Oh.
I think you're right, Ryan. I get a lot of pushback from social workers with the department. It's not from the foster parents or the CASAs who don't want the children there. It's that social workers don't know how to have this hard conversation, including the youth. And so they want to like limit me on what I can say in the meetings, or kind of, you know, not dance around the elephant in the living room, but we really need to be having honest and transparent conversations, not with just with parents, but also with the youth whose lives this has impacted. So we're talking about concurrent planning. This is what we do is we have a primary plan and we have a concurrent plan, which is your backup plan. And I like to talk about this and say it in a way that if anything, for any reason, if the children were not able to go, or the child or youth was not able to return home, where would that youth be, or where would that child be? What would their permanent option look like? And I mean, part of what we do in the permanency from day one is we ask the parents. So when we ask the parents in the meeting, we ask the parent what their preferred placement is. We ask the youth what their preferred placement is. If they're relatives at the table, we ask them. Oftentimes I hear they'll say, well, we want them to be placed with Aunt so-and-so who's not at the table currently. So then we need to reach out to the aunt and start having her be part of our conversation. And we ask the foster parent or the caregiver, are you a permanent resource? And sometimes that's shocking to the department. Foster parents say no, and the department has other plans for them. So it's interesting. We have these meetings every 90 days, and it's interesting to see the changes over time. We have the concurrent planning. If we're doing this consistently and in every meeting, we're not going to delay permanency. We're going to see those delays in permanency reduce, because we're going to always be talking about that secondary plan. We're going to be planning towards that while we're planning towards the primary plan as well. This is kind of what I'm seeing is in the areas that I cover, it's kind of a change of thinking. So I've been doing this for almost a year now, this permanency from day one. And lots of social workers and supervisors will still say, we don't have a concurrent plan, or we don't want to talk about a concurrent plan. So it's really pushing the practice in a different way. And that's not always easy. You can go ahead, Debbie, you can go to the next one. I just wanted to share that piece. So this is our shared planning meeting umbrella. These are all the different types of meetings the department has under the shared planning umbrella. And most of these meetings we can combine with our permanency planning meetings in the grant. There's a couple that we don't. I think it's LICWAC, and then there's BRS staffings that we don't, because those are directly focused about the youth and not really about the safety or what's going on in the home. They're about the youth's progress and are they in the right level of BRS, which is behavior rehabilitation services. Go ahead, Debbie.
I'm sorry, I hit the wrong button.
That's okay. So the permanency from day one grant that Debbie kind of talked about earlier it's a federally funded grant that the state of Washington has to address permanency. And we address those by having expedited permanency planning meetings. So what happens is when a case comes into the grant, they get randomized in after dependency is established. And we have their first meeting within 30 to 45 days. And then we have a permanency planning meeting every 90 days throughout the life of a case until permanency is achieved. So even if a parent's rights are terminated, we follow that youth as facilitators. We follow that youth all the way through until permanency is achieved. So they don't have to tell their story over and over and over. We pick up every 90 days where we left off. And those successful components of the teaming process are met. So that's really about inclusivity, bringing the right people to the table, not just having. Debbie, are you writing something in the chat?
Yeah, don't worry about it. I was just
Okay.
adding to what you're saying without interrupting.
Gotcha.
Just
Yeah,
ignore
it's
me.
okay.
I'll yell out the chat.
You're doing your own thing there. Yeah, so we want to bring the right people to the table. So what we're finding is when we first started these, oftentimes it was just the department at the table. Parents weren't being invited, their relatives weren't being invited, their supports, community partners, tribes. So we're making sure that we're reaching out to all of those folks ahead of the meeting. We're asking the families, the parents, and the youth who they would like to see at the table. And we're trying to get as many people to the table as possible to really build a team around them. And there's also a piece that's about accountability here that I can appreciate. While we always want our parents to be accountable for the actions, and Debbie kind of talked about that earlier, we also want the department to be accountable. And so every 90 days, by meeting every 90 days, we're making sure that's happening, because the department has action steps, making the referrals, engaging the parents, having those parent worker visits, doing the health and safeties with the children. And in between those 90 days, we have meetings. The facilitators, we check in with the social worker and the supervisor and see if those tasks are being completed. So there's a lot of accountability there that they're not necessarily used to. And it seems to be what the feedback initially was kind of rough. And now the feedback to me is I'm seeing a lot of those action steps are just being completed as a matter of routine. And it's helping move their cases along. And so they're appreciating that. So change is always hard when you first start. And then the grant provides a grant facilitator to lead all the meetings. So each family is assigned a permanency outcome facilitator. We refer to ourselves as POFs, and we follow that case through. So very rarely will you have another facilitator step in for a facilitator, barring there's no emergency. So it'll always be your same POF. And what we're doing is we're kind of coming in as neutral as we can be. So we're not deeply involved in the case. We're facilitating that conversation. Some pretty difficult conversations, especially when we're talking about concurrent planning with families and with the department. And then we're just really trying to ensure that there's transparency. So by me, when I send out my invites, I send out the permanency planning matrix. I attach it to every invite. I send it to parents as well. And so when we're talking with parents, we're telling them ahead of the meeting, we're going to talk about this. So ask them to be thinking about it and be mindful about it. Everybody gets the same information when we do the invite. So everybody gets the agenda, everybody gets the permanency planning matrix. So everybody kind of is prepared for that meeting. So what Debbie was saying in the beginning, lots of folks come into these meetings, they have no idea what the meeting is about. They're just told they get an invite, you have to come to this meeting, but there's no agenda, there's no understanding of what the meeting is going to be about, and it can be very intimidating. So with this new process, we have a set agenda for every meeting, and people get it in advance and they're able to ask questions and prepare for the meeting. And I have, like, you know, in the beginning, just some kind of live feedback from what I've seen is I had a really challenging father, really challenging with the department, really challenging to engage. And the pre-meet, we'll get to the pre-meet discussions, but he comes with a notebook and he writes down all the things that he wants to say because he's read the agenda and he's prepared. And he's one of the most prepared parents I have for the meeting. And I was just, makes me smile because in the beginning he was kind of scoffing about this whole thing. And now he comes in and he has really valid points and he has a lot to say that I don't think he was really being heard because he gets frustrated really easily. So we give him breaks, and I give him breaks and let him read kind of what he wrote so he's able to engage in a different way. Go ahead, Debbie.
Sorry.
That's okay.
Yep.
And I talk really fast, and I'm sorry about that. So if anyone has any questions, just go ahead and interrupt me or throw something in the chat. So the team approach to case decision making, this is also very interesting. So bringing the folks to the table and kind of trying to change the practice in that it's a team decision. The team at the table is going to help make the decision about the case, and with the parents being the experts and their family, and not the department dictating what's best for the parent, or the department dictating everybody gets supervised visitation, and everybody has to complete their services before the case is moving forward. So we're really finding that bringing these teams to the table and we talk about visitation, we talk about what it would take for them to, if the parents are in supervised, what it would take, what does the department need to see for the parent to move to monitored or unsupervised. And oftentimes we're finding that that's a really hard question for the department because they're not sure whether visitations are supervised to begin with. It's just kind of what we do. And I can remember being in the field and just going to that supervised just as a protection right off the bat. But then you need to move forward. You need to figure out what is the concern with you having monitored, or we're able to have family who's able to supervise the visit, which then takes it out of the department. It doesn't have to be in DCYF offices. It can be in family homes in a more comfortable, less restrictive setting. Opportunities to share information. This is a really good time for parents because they're able to prepare for the meeting and they can come in and they can engage and share information about them that they didn't know. And I'm going to give an example of that. We have a father from Guatemala, and the social worker thought that he had delays, and she wrote in her reports he had cognitive delays, and she warned me about his cognitive delays. And when we finally got him to the table, we found out that he speaks Concabal and he doesn't speak Spanish. And so there was no cognitive delay. They were using an interpreter, the wrong interpreter. So he was struggling with that language, that being his secondary language. And so we were able to get the right interpreter to the table, and we learned so much about him. And we learned that he's been very engaged in services. He's completed parenting, all of these things that he was in non-compliance with that we didn't know about. So it's really important also when you're working with families that don't speak English, that you have the right interpreters at the table. We're doing a lot of work around that in our region as well. And then just modeling the respect, inclusion, and transparency. I think it's hard for the department to kind of change the shift into being transparent about the information. And it's not really what I'm finding. It's not really about the parents. It's about they're worried that the attorneys are going to use this against them in court if they're open with everything they have. So they feel like they kind of have to have some cards in their pocket. And so encouraging them to be more transparent, to be more open, to come to the meeting and be ready to talk about that PPM, that permanency planning agenda that we have established, because we as POFs are going to ask the department to talk about what's going on with the family, talk about what it is that you need to see, the changes that you need to see with the family, and why are the children still in care? Why can't the children go home? And we're also addressing safety, permanency, and well-being of the family. So we're always talking about the well-being of the child. We're getting updates. We're including foster parents. That's something that's different and is really in the areas that I cover, and I cover 5. I don't know. I don't even know anymore. I think 5 offices, maybe 6. But having the foster parents come to the table is really important. And I have had foster parents tell me that they've had many, many children in their care, and they have never been invited to these kind of meetings. So it's really important for them to come. And I just had a meeting last week where mom was having some medical issues, and the foster parent and the mom asked if they could communicate via text about the child's ballet recital. And mom was able to send an email out today, and she was able to attend that virtually. And that was through the partnering with the foster parent. So it's just a special kind of relationship that people are able to build. I'm just going to see there's something in the chat. Is this way of meeting in place now? Alice, it's not. It's in region. Oh, Debbie was answering that. There you go.
Sorry.
That's okay. I just wanted to grab that chat question. And I think our hope is that eventually this will be the way of meeting, and this will be the shift that the department is making. But right now, the permanency from day one is we're doing an evaluation, and we end in September 2023, and we'll know more about that then.
So I was just going to add to that, Paula, in that one of the things we get from workers is, why are you doing something so new? This is actually written in DCYF policy, how these meetings are supposed to go. Not as often, so they're supposed to be held every 6 months, but what we realized is 6 months is too long, right? And so our grant strategy was to do these every 3 months and maybe extend them out. We could maybe look at every 4 months. That's how they do them in Region 4. But we knew that we needed to have a facilitator that could be neutral and lead the discussion in a way that made it teaming and not a case review, supervisor review, compliance review. That's not how these meetings are set in policy. And so I know Paula personally has said to a supervisor, this is all in policy. This isn't really anything new. There's a couple things we're doing a little different that aren't in policy that Paula's going to talk about, but really, this is really clearly defined as a shared planning meeting practice, is clearly defined in research and for a long time in our policy, that these are how decisions are to be made about case planning. And somehow we've kind of gone a little sideways, and we're trying to bring the road back to where this teaming decisions.
Yeah, and I think that's important. That's a very important piece of this too, Debbie, is that it is in policy, and we've kind of gone sideways with it. And I think sometimes, I think the department staff might feel that it's easier just to tell a family what to do, check off those boxes in compliance, because it's harder, I think, for department to really evaluate the behavioral changes and talk and look at kind of like a clinical. I think that's what the challenge really is for folks. And I think we're getting there. I think that coming in when we started this, my very first meeting, I had nobody from the department show up, which was, how can I have the meeting without, the social worker got on for a minute and she said, oh, I have to go because I didn't bring my phone charger. And we had the dad there, and we had relatives there, and we had all these people, and I had worked really hard to engage lots of folks. And then the department said, yeah, I don't think so. But I ended up having the meeting anyway, because the dad was already engaged, and I could not bring myself to cancel the meeting and reschedule it. So, but I think
Debbie,
we're making a lot of progress.
Debbie or Paula, if an advocate wanted to request this type of meeting, how might they do that? And they're in the grant area that you guys are serving.
So
want me to answer that?
Go ahead, Paula.
Well, so if they're in the grant area, the cases are randomized in. So every Monday we get something called the AOC court data, and the cases that are eligible for the grant come in, and we put the our CQI person puts them on our spreadsheet, and we go in and verify whether they're eligible. So a family cannot be an FRC because we wouldn't be able to evaluate what intervention is working, so they're not eligible. And there's a couple other things that make a family ineligible, but we click it, and it's just like that. It's a randomization. It tells you, yep, the family's in, or nope, the family's not. I have had supervisors send me cases and say, can we do this case? And I say, sorry, we can't. So it's a complete randomization in how they get into the grant. So they can't really request it. I appreciate that I've heard that from attorneys, even that attorneys that will say to me, hey, I know of a really good case that would be great for your grant intervention. And I appreciate that. And I'm excited to hear that people are excited about it, but they're randomly chosen.
I just put in that anyone though can ask for a shared planning meeting. So it doesn't have to be a grant
Right.
case. So if
Yeah.
you're in a case, the grant case goes every 3 months. So we have a more difficult time doing meetings in between. We had an attorney just say, can we do these every month? Like, these are so helpful. And a parent's attorney, which at first we thought we were gonna have a lot of pushback from them. We can't do these every month because we're actually evaluating how we're doing with, if doing these every 3 months is really going to work or not. So we really can't change that. But in terms of just general cases, anyone can ask. You can go to your worker and say, I want a shared planning meeting. I've never been invited to one. Why not? I can tell you that I have been on cases where, and I've read where workers have said, well, we don't invite advocates to these meetings. And which is why we wanted to share the shared planning meeting guide, which I'll put that in the chat thing too, as soon as I find it, because it talks about the different meetings and who's supposed to be invited. The other piece of this is that it's not limited to that, right? We really want to have all key participants in these meetings. I mean, these meetings are to make team decisions for cases, for people that are invested in these families. And so that's who we want to have to be a part of these.
But and I also just want to add that even if so you can request a shared planning meeting, but you wouldn't necessarily get the same format. So the people who we're the ones who are doing it in this kind of format from permanency from day one, having the set agenda, and those kinds of things are the POFs under this grant. So it would be great if FTDM facilitators were also following this, but I know some of them are trying to right now, especially in Region 1. But I don't necessarily know that the rest of the FTDM facilitators are doing that because they're doing all the other FTDMs, and they also haven't been trained in the way we have been trained about in the beginning of this grant. So you might get a shared planning meeting, but it might not look exactly like this. Oh, go ahead, Ryan.
No, I was just going to say that we've been told that those are internal meetings, and that's where you're discussing internal strategy, and so that's why we're not invited.
Oh, wow.
Ouch. Yeah, no,
Yeah,
that's not true.
That's very unfortunate. I mean, that kind of goes against everything that we're saying here, right? The inclusivity of folks, bringing the team to the table, getting the right people there. Yeah, I rarely have. I have never heard of that. Not inviting CASAs. I mean, that's one of the. I always ask the social worker who's the attorney and who's the CASA, and make sure they get the invite.
Or advocate.
Advocate, yeah.
I will say this, I'll throw this out there, that if you run into a struggle with either being a part of a shared planning meeting, or we've even had resistance to inviting parents. So I'm actually not surprised, Ryan, when you say they don't want their advocate, the court advocate there. But if you run into issues, feel free to reach out to me, and I will help to facilitate moving something forward if I can. Hopefully it's a misunderstanding, but regardless, I'll do, I'm willing to reach out to the management or connect you with the management or whoever might be over that too. We've had really great success and really great support with the managers in regions 1, 4, and 6, and that's where the grant's located. So especially there, they are embracing this. We feel like we're making some change. And so in region 4, particularly is probably the one region where I think they're trying to have all their facilitators do the same kind of engagement that we're doing in the grant. And they actually have moved their meetings to every 4 months instead of every 6 months for the same reason, along the same principle that meeting more often. We worried about people having time, and people at first grumbled and said, we're not going to have enough time, we're too busy, which we all understand. We've never had people not show up because of time. We actually, all those parties are showing up. Other than, like Paula said, sometimes it's our own agency that hasn't. So just to throw that out there.
Yeah, I had a meeting in Region 4 that had 26 people show up. Shocked me. But 26 people, that was it's hard to facilitate, but we had a great conversation, made a great plan. And it was amazing to see all the support that this family had in the community. So the team approach. So what is it? The question is, what does this look like to you? And I know we're running close to time. So I think this is a good question to the department is when we're talking with them is, what does that look like for you? So we're not excluding folks. And we, like Debbie was saying, like we've made so much progress. In the beginning, it was folks thinking like, well, defense attorneys aren't going to want to be there. We're going to have the meetings without them. I rarely have a meeting without a defense attorney showing up. It's pretty amazing. And they're very invested. We also have PFD1 work groups, and we have defense attorneys who volunteer their time to participate on those work groups as well. So it's pretty great. But I think just really looking at teaming, and when we talk about the team for the family, I like to ask the family, who are your supports? And I talk to them about building a team around them and why it's very important to build that team around them, because we have a lot of folks who are houseless who come to our meetings who have their children removed, and so they really don't have their biological family be here. But we talk to them about who are their supports, and we try to get as many of those people at the table. And what we do is this pre-meet. So when we get a case, the POFs get the case. The first thing we do is we start doing these pre-meets. We do the pre-meet with the social worker and prepare the social worker by giving the social worker their agenda, telling them what we're going to talk about, making sure they understand. We're going to talk about concurrent planning. We're going to ask you, what are the safety threats, and not what are the safety threats when CPS removed the kids, because sometimes they've changed. We're going to ask you, what are the safety threats today that are preventing the children from going home? And then we call the parents, and we have pre-meets with them. And so we talk to them about the Permanency from Day One grant. We talk to them about the purpose of the meeting. Who do they want at the table? What do they want to talk about? I share with them the agenda, and usually I go through the agenda with them while I'm on the phone with them, and let them ask questions. And sometimes when I'm talking to a parent and I'm seeing that it's overwhelming, or they're just not understanding, I give them some time to think about it. I send them the agenda. If we have a parent flyer, I send them that, and then I call them back like in a couple days and have another conversation. So it's not about just checking the box that it's done. It's really helping them to understand why we're having the meeting and what it's about. And then we call the youth and talk to them as well. And I do the same thing oftentimes for youth. I do the same thing where I tell them about it, then I call them back and talk to them about it, because it can get confusing when I'm calling them and then they think I'm their social worker. And so we're just trying to really flesh that out before the meeting. And who do they want to see at the table? So when all the teams that I've invited, they've always brought someone that isn't on the social worker's list of people. It's their best friend, best friend's parent, a fictive kin where they're going to be placed, a teacher. I have a young girl who brings her teacher. She is from Guatemala, and she brings a teacher that she had a year ago. That teacher always makes the time to come to the meetings and support her. And then we also do pre-meets with the caregivers. We call the foster parents or the caregivers, and we call the relatives and invite them to the meeting. And then anyone else that the parents want to say, so if they want their PCAP worker invited or their FPS worker invited, I just generally send them an email and let them know. They're pretty well versed in our region about these meetings, and then I send them the Zoom link. So we have a lot. I think that's one of my favorite parts about this, is that engagement with folks before the meeting, so they can prepare and they feel empowered when they come into a meeting, because they know where they're coming in. And I always tell them, we're not going to change the agenda. You can count on that agenda unless something tragic happens. I mean, I did have a case where I did all the pre-meets, and the foster parent's husband passed away. So he passed away the day before the meeting. The child had been moved that night. And so we really had to kind of change gears and talk about the change of placement and include that in FTDM. But that parent was very understanding, and we talked to the parent ahead of time. I had the social worker call with me, and we talked to her about what happened. But other than that, the agendas are pretty solid, and we don't waver from them because we want people to be able to be prepared. Does anyone have any questions about the pre-meet? There's a lot going on in chat, and I'm trying to ignore it, but
I'm just kind of writing about it, but one of the things I wanted to add, Paula, that you said is that you saw under that umbrella of shared planning meeting, there's all these little meetings that workers think they have to do separately. And what we do is in this grant, our thing, we combine them into one. I mean, and that's why we feel like doing meetings every 90 days, we're not really wasting anyone's time because there's not all these extra little meetings that workers have to go to where they may not invite you because they just saw you a month ago and they think, oh, they may not, the court advocate probably doesn't have anything to say about the BRS piece, when really you're supposed to be invited to all of those. So what we do with the grant meetings is we say, we're going to combine them. We're going to have these often enough to where, you know, the difference between an FTDM and a permanency planning meeting are really just two pieces. We make sure we talk about a transition plan, if the child can change placement and the change of placement. We kind of already do that in our permanency planning meetings anyway, but we just really make sure that piece is covered and it's an FTDM. So now it's an FTDM and a permanency planning meeting. Whereas in non-grant cases, you can have a permanency planning staffing and the next day have an FTDM because they refuse to put them together, and it's ridiculous. And so we're really trying to make this easier for everyone and have it make sense. Go ahead, Paula.
And oftentimes I was just I'm glad you said that, because I have a case where we have a medically fragile child, and so instead of we learned that in the beginning that we needed to talk with DDA. So we invite DDA to the meeting, and the feedback from DDA has been great. They love being invited to the meeting. They have connections with the caregiver, the parent, they can educate the parent on what's going on. And so they're able to talk to everyone at the same time, and they really like being part of that conversation. And then people can ask questions of them also. So they're not having to have 10 phone calls from different people, and they can answer these questions in these meetings. And I also facilitate, not all the POPs do this, but I do this. I facilitate all the FTDMs that are needed outside of PPM. So if there's going to be like a trial return home or removal, and I can't incorporate that in my PPM, the social workers just let me know, and I make sure I make time for that, and I facilitate that meeting. So then that family doesn't have to come in with a new facilitator and have conversations that they've already had. And I make sure the same team comes back together. And that's been really effective. We've had a lot of, I have 5 cases dismissing in December in this grant. So that's pretty exciting, that because we've had these meetings and we've gotten to that point.
These were assigned in January, October to January. So, and then some even after that, but that's when we started.
I've had 1 dismissal already, and then I have 5 coming up in December. So, and I had one time I called the mom and I told her about this, and she started to cry, and she said she felt like she hit the lottery. And we had her first meeting, and there was one, the kids had been in care for so long, 19 months, and it was because she didn't have housing. And so all that needed to be done was the social worker needed to call the shelter in this county and say that the children were ready to return to mom. She just needed housing. We put that down as a task. The social worker did it that night by 5 o'clock. It was 2 days later, the children returned home to mom in the shelter, and she now has her own apartment and she's doing amazing. So it's just really, I think it's really getting the people to the table and having the conversation. I mean, we're really just having a conversation in these meetings. What needs to happen next, and how do we get there? Does anyone have any questions about the pre-meets? Because that is a different part of practice. So FTDM facilitators aren't doing pre-meets with the folks that they're, and also we as POPs invite everyone. So we send out all the invites, we manage all of that. So it takes that off the workers. Okay. So I kind of talked a bit about some of this, and the things that we talk about are the currency.
Wait, what?
Oh.
What does POS mean, or POS again?
Oh, sorry, it's POS.
What's
it's
that
permanency. Yeah, sorry, Alice. It's permanency outcome facilitator. So it's our roles. It's just, we call it, you'll see it in different things. What's that?
Permanency Outcome Facilitator, POF.
Yes. Yes.
Okay, thank you.
Oh, you're welcome. And Debbie dropped it
That
in the
is
chat
actually a
also.
region, you can thank Region 5. So someone asked about Pierce County, that name came from them. So I'm not exactly thrilled with the word POF, but that's what they came up with, and we tried to be consistent.
Yeah, and it really is different from like what they say, the FTDM facilitator, because we really are focusing on permanency, and we really do that deep dive in the case every 90 days. Or we have these meetings are about 2 hours, and they're very in depth, and they're very concrete, leaving there with action steps and what needs to happen next. And there's follow up on our part as the permanency outcome facilitator. So you don't just have your action steps. A lot of times as a worker, I remember there being lots of steps, right? And then you get 5 new cases and you don't follow through with those steps. Well, the thing with we do is we help those workers follow through with those steps. We reach out to them, we read the case notes to see if they're being done. And it's easy to see when service referrals are being made. I've asked for my AAs and supervisors to document in their soup notes the ask about the action steps and then document that they're completed. And they're doing that now. And it takes a lot less time for me to see that those action steps are being completed than calling the social worker and getting them on the phone. So trying to reduce their workload, but also trying to make sure that they're doing the things that need to be done. So this current safety risk, this is a big issue. So
Paula, I'm going to stop really quick because Nancy asked a question about this program being offered for all. And I just want to say is that we are having a very rigorous evaluation of how this works. We hope it's funding. One of the things that's different from a facilitator that's a grant facilitator to a facilitator that's maybe in a regional office, like in Pierce County, is that they pull those facilitators and they give them other duties to do. And our whole focus is that these facilitators need to be doing these meetings to ensure everything that Paula's saying that they do. And they don't have time. Paula has 31, 32 families right now. She doesn't have time to do other things to really do the job that she needs to do to make these happen, to move these cases along. And so we're really trying to show that that does make a difference in timeliness, in an engagement. We know it's making a difference in engagement. We're hearing from parents. We're hearing from court advocates that are involved. We're hearing from defense attorneys that are asking us for more meetings. But hopefully our rigorous evaluation will convince the state to fund it, because we do still have to convince management. And there is some that just, that we're working against a system, like I said, and Ryan and I have had discussions around this, that's very compliance-based rather than engagement-based. And we are hoping that we're able to really show with our evaluation that this does make a difference. So that's what's needed. And we have 2 more years of this. The evaluation is ongoing right now and will go through an additional year. So go ahead, Paula. Sorry, I just wanted to.
that's
tackle
okay.
that.
Gabrielle, where are you? You said that would be so helpful here. What region are you in?
I'm in Pierce County,
Oh, gotcha.
and I think this would just be revolutionary. I'm a returning CASA, so I haven't been practicing in this recent time, but in the time when I was practicing, this would have just made life so much easier. It would have taken so much pressure off the social workers that I worked with, and the parents might have been able to understand better what was going on.
Right. Those are the things that we're finding. Most workers are embracing this. They're allowing, the weight's not on their shoulders to make, decisions in isolation. They're able to rely on a team and feel like they're supported. And we had one supervisor tell Paula, she's finally feels like she's able to do what she's always wanted to do in this job with these meetings. And I'm probably not saying it exactly right, Paula. Paula always says things better than I do, but Paula knows what I mean.
That's not true. I just wanted to go back to teaming when you said that teaming something that team approach. Something I ask social workers to do in the meeting is to create a team email in our first initial PPM. And so the feedback from that has been really great. And this was something that an office was already doing. It was super effective. It was working. So social worker is not getting 10 calls from all these different people. When she has visitation notes, he or she sends them out to the team. When she has progress notes about the parent, she sends them out, and it includes the parent. So they're getting all this information, they're sharing it, and it's just increasing that transparency. And then what we've seen from that is that parents are more trusting of the department when we're being transparent. Oh, we just got a 2-minute warning. Okay, so I kind of talked about all these things already. The timeframes, we meet every 90 days. So I don't really have much more to say here. These are kind of things we've already gone over. So if anyone has any questions about those things, I think the biggest thing is getting social workers to talk about the current safety risk versus what happened. You know, I'll give you an example of that. I have a social worker comes into every meeting, talks about the dental neglect of a child. She's been in care for almost a year. Mom can never change what happened. She can never change it. So what's happening now? What's the safety threat now that's preventing that child from going home? Because mom's getting her mental health needs met, which was what was part of the reason. Her mental health needs weren't being met. She wasn't able to take care of herself or her child. That's different now. So can I get him? He's now gone, but really trying to get him to the next social worker to articulate, why can't this child go home? What is happening? Lots of people needing to leave. So do you want me to talk about this piece, or?
I think just really quickly, the only other piece that we do that's not in policy is we give family the option for family breakout time, which is where they can go. Go ahead, Paula, really quick. And if you have to leave, we're sorry, Ryan.
Okay, family breakout time happens when in our subsequent PPMs. Doesn't happen in the first PPM, but happens in the meetings after. And what it happens is we talk about the safety concerns, we talk about the conditions to return home, and after the family hears all of that, we ask them if they want to have this breakout session. And if they do, we put them in a breakout session with the family and their supports, and they kind of come up with a plan. What is it going to take for them to move the needle? What is it going to take for them to move the next step? Sometimes I'll give them that question, like, what is it going to take from you to go from a 5 to a 7 or a 7 to, what's going to happen? And they have 15 minutes and they go in and they talk about things. And sometimes families don't want to use it because they want to just talk about it right in front of you and right in front of the team. They want to have a really open conversation. And sometimes families do. And go in and they are coming out with some really amazing thoughts, really amazing insight into the problems that they're hearing and what they can do. And I'll give an example of a POF that she had used the family breakout time, and child couldn't go home because the parent worked at night, and so they didn't have childcare. The family went in, they did a wraparound. They came out with a plan of who was going to watch the child, what times, and when the parent was going to sleep. And the parent was able to have the child return home because they were able to work this out in a breakout session. I know I'm talking really fast because I know it's 7:32.
Right. I think
I could give you lots of examples of how family time works.
I think
it's pretty
we've really
amazing.
I think we've really said this, and we can just say, if you have questions, email us. I think that we love to talk about it, in case you can't tell. And we're really a believer in this. Like, we really believe that this is how practice needs to be. And we really believe that families are the experts of their case planning and need to be included in equal partners, as well as court advocates, parent advocates, and defense attorneys. We are not afraid to have meetings with them. So
we actually want you all there. We want the team there.
Yeah. All right. So thank you. Sorry we went over. Ryan, anything else you need from us?